Hello, I'm Amy O'Donnell, the Communications Director for Texas Alliance for Life. Welcome to this week's TAL Update. We here at Texas Alliance for Life have closely followed the Zurawski v. Texas case from its filing in March. In this case, the New York-based Center for Reproductive Rights is suing to greatly expand the exceptions in Texas's pro-life abortion laws, including the Human Life Protection Act. This past Friday, August 3rd, a state district judge in Austin issued an injunction in the case. That injunction was a setback for unborn babies who would otherwise be protected from abortion by the law, including the Human Life Protection Act. The injunction sought to block Texas's protections for babies facing life-limiting or fatal diagnoses, and it vastly increased the exception far beyond cases when the pregnancy endangers the mother's life. That has been in law for a decade. An example of judicial overreach, the injunction showed a blatant disregard for the legislature's careful crafting of our laws protecting unborn babies. We oppose the injunction. No disease or disorder ever justifies intentionally taking the life of one's child, born or unborn. We applaud the Texas Attorney General's office for filing an appeal the following day in the Texas Supreme Court, effectively blocking the injunction and allowing the exception language approved by the legislature to remain in effect. The Human Life Protection Act, which went into effect in August of 2022, protects unborn babies from abortion from conception to birth. The life of the mother exception allows a physician to intervene if necessary to save a mother's life when, in the exercise of reasonable medical judgment, the pregnant female has a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that places the female at risk of death. Nothing in the law requires the woman's death to be imminent. That language is the same as in a 2013 law to protect unborn babies from abortion beginning at 20 weeks. No physician has been prosecuted for performing abortions to save the mother's life under the pre-Roe laws, the 20-week law, or the Human Life Protection Act. While the law is clear, we believe some doctors are not apprised of the actual language, resulting in poor, even life-threatening care for their patients. Professional organizations like the Texas Medical Association, ACOG, and the Texas Medical Board are the proper sources for guidance and rules for physicians, not the courts. We will keep you apprised of how the Texas Supreme Court rules. Thanks for tuning in to this week's TAL Update. We hope to see you again next week.